Rise, something happened in Florida that few people believed they would ever see with their own eyes. At 6:47 a.m. on January 17th, a convoy of federal vehicles rolled through Palm Beach and stopped outside one of the most recognizable private properties in America. 12 vehicles from the United States Marshal Service arrived with a federal court order in hand, not for show, not for symbolism, but for action. This was the beginning of a real, enforceable asset seizure tied to a civil fraud judgment totaling more than $500 million. This was not a warning. It was not a negotiation. It was the federal government carrying out a court's final decision against a former president's primary residence. When federal officers arrive at dawn with legally binding seizure authority, it means the legal runway has ended and enforcement has begun. This moment didn't come out of nowhere. It was the end result of years of litigation, months of delay, and countless legal maneuvers that finally ran into a wall that could not be moved. Courts had already ruled, appeals had already failed, deadlines had already passed. What unfolded that morning was the legal system doing the one thing that gives it real power, enforcing its judgments. For a long time, the case lived in filings, hearings, motions, and television debates. On January 17th, it moved into the physical world. The trigger for this action was simple and devastating. After every appellate option had been exhausted, the New York Attorney General formally requested federal assistance to enforce the judgment across state lines. Just 3 days earlier, on January 14th, an appellate court rejected the final attempt to pause enforcement. That denial wasn't narrow or procedural, it was sweeping. A 4-1 decision upheld the original fraud judgment in full, including interest, that pushed the total to roughly $540 million. The court's message was unmistakable. The evidence was overwhelming. The fraud findings were sound. Further delay would only reward obstruction. At that point, the law no longer cared about rhetoric, influence, or political identity. It cared about compliance. When a judgment debtor refuses or fails to satisfy a lawful order, courts have tools, and when those tools cross state lines, the federal system steps in. This is exactly what happened next. Behind the scenes, the escalation was fast and unusually decisive. On January 15th, attorneys from the New York Attorney General's office filed an emergency request in federal district court asking for immediate interstate enforcement. The filing wasn't symbolic. It included nearly a year's worth of documentation showing missed deadlines, rejected proposals, disputed valuations, and repeated failures to secure an acceptable bond. According to sources familiar with the review, senior officials described the documentation as exhaustive, meticulous, and impossible to ignore. The federal judge overseeing the request acted with rare speed. Within 18 hours, an order was issued authorizing enforcement. By the morning of January 16th, the U.S. Marshal Service had formal approval to proceed. The order named multiple Florida properties, including the Palm Beach estate, a major golf club, and additional assets identified as eligible for seizure. The language of the order was blunt. The court found a sustained pattern of delay and obstruction and concluded that immediate enforcement was necessary to protect the integrity of the judicial process. That language matters because courts do not speak casually. When a judge writes that postponement would reward contempt for the law, it signals that patience has already been stretched beyond its limit. When the convoy arrived the next morning, witnesses described a tense but controlled scene. Private security initially resisted entry, attempting to stall or redirect access. That effort ended quickly. the lead marshal presented the federal court order directly to security leadership and made the consequences clear. Compliance was mandatory. Obstruction would result in arrests. There was no middle ground. Moments later, a deputy marshal formally served the seizure notice to the property's management. The words were not dramatic, but they were historic. By order of a United States District Court, the property was now subject to judicial seizure to satisfy a civil judgment. With that statement, a legal abstraction became a physical reality. The impact was immediate. Legal circles reacted with shock, not because the outcome was legally unsupported, but because of who it involved. Asset seizures against powerful figures are rare, but not unheard of. What made this moment extraordinary was that it involved a former president's personal and commercial empire. The message was unavoidable. Civil judgments apply regardless of status, wealth, or political history. Claims of persecution lose their force when enforcement passes through multiple independent courts in different jurisdictions operating under different authorities. This wasn't a single prosecutor or a single judge. It was a chain of decisions, each affirming the last, until enforcement became unavoidable. History offers parallels. During the savings and loan crisis, powerful executives faced aggressive civil enforcement after fraud findings. Courts rejected claims of political targeting and proceeded anyway. In other cases involving high-ranking officials, cooperation shortened the process, while resistance only made consequences worse. The pattern is consistent. Delay tactics do not eliminate judgments, they compound them. What pushed this case over the edge, according to legal analysts, was a discovery that shattered remaining trust. Earlier in January, a proposed bond intended to delay enforcement was revealed to be backed by assets already tied up in other financial obligations. The same properties had been pledged multiple times, making them legally unavailable. The court viewed this not as a mistake, but as a material misrepresentation. That finding changed everything. Misleading a court about asset availability isn't a technical violation. It strikes at the heart of judicial authority. The enforcement order explicitly cited this issue as evidence of bad faith. At that point, the court's patience ended. The broader implications go far beyond one case. Civil justice depends on enforcement. If judgments can be delayed indefinitely through money, power, or political pressure, then court rulings become suggestions instead of commands. That reality would devastate ordinary Americans who rely on courts to resolve disputes and enforce their rights. This situation has placed political leadership in an impossible position. Defending the rule of law means accepting enforcement even when it targets allies. Attacking enforcement means arguing that some individuals should be immune from court orders. There is no comfortable middle ground. Voters understand the difference between disagreement and defiance. Legal scholars across the ideological spectrum have acknowledged the same truth. Whatever one thinks about the underlying case, the procedural path has ended. Courts cannot function if their judgments are optional. When enforcement begins, it means every legitimate challenge has already failed. The financial consequences are severe. The seizure order allows for inventory, valuation, and potential auction of property. Forced sales typically yield less than market value, increasing pressure to liquidate multiple assets. Beyond the numbers, operational disruption looms. Properties that generate revenue may fall under court supervision. Employees, contracts, events, and memberships all face uncertainty. The reputational damage is global. Business partners, lenders, and licensing entities reevaluate risk instantly when enforcement begins. Financing discussions freeze. Negotiations pause. Brand value erodes under legal pressure. Politically, the imagery is powerful and unavoidable. Federal marshals enforcing court orders create visuals that no messaging strategy can fully counter. Polling already shows shifts among independent voters who view accountability and equal application of the law as non-negotiable principles. Inside the legal team, reports describe intense disagreement. Some arguments argue that cooperation is the only path to limiting damage. Others push for continued resistance, believing defiance energizes political support. Courts, however, remember cooperation. They also remember obstruction. That memory carries consequences long after headlines fade. Public reaction has been explosive. Supporters flood social media with accusations of conspiracy and persecution. Critics point to years of delay as proof that enforcement was inevitable.